Welcome to the Deep Dive. Today, we're tackling one of the most fundamental, complex, and frankly, most politically charged questions in American law.
Right.
Who exactly is a person under the U.S. Constitution, and what rights follow that designation?
It's an essential mission for us today because the political rhetoric and the legal reality surrounding the rights of individuals unlawfully present in the U.S. are often wildly out of sync.
Worlds apart.
Worlds apart. We are sorting through the bedrock legal sources, Supreme Court precedent, statutes, and the Constitution itself to clarify a major paradox. How can an individual who is, unlawfully present in the U.S. still possess rights protected by the supreme law of the land?
And our job is to give you the shortcut to being well-informed on this. We need to distinguish clearly which protections are deeply rooted in the Constitution, applying to all persons within U.S. territory,
Right.
versus those privileges that are purely set by Congress via statute and are reserved only for citizens or lawful permanent residents. This distinction is everything.
It is absolutely everything. To understand the legal landscape, you must first understand that the debate over constitutional rights is fundamentally different from the debate over statutory benefits.
Two different things.
Two completely different things. And we're starting with the Constitution.
Okay, let's unpack this immediately, starting with the constitutional cornerstone. The distinction hinges entirely on, one choice of word made by the framers and confirmed by the courts: person.
Precisely. This entire structure, it all rests on the language found in the Fifth and 14th Amendments. The architects of American law, they chose their words with extreme care.
And the courts have backed that up.
And the Supreme Court has spent over a century confirming that, yes, that choice was deliberate and meaningful.
Let's look at the text, because it is so specific. The Fifth Amendment part of the Bill of Rights, it says, "No person shall be deprived of life, liberty, or property without due process of law."
It says person, not citizen, not legal resident, person.
And then that concept is just amplified after the Civil War.
Oh, dramatically. The 14th Amendment reinforces this by placing the same requirement on the states. It guarantees due process and, critically, equal protection of the laws to all persons within that state's jurisdiction.
So this is the crucial insight you need to remember.
It is. The framers utilized person and people, and the word people is actually used 9 times throughout the Bill of Rights, rather than restricting these core protections exclusively to citizen.
That distinction, person versus citizen, is a massive legal pivot point. I mean, if the framers had used citizen exclusively in those foundational amendments, this entire legal structure protecting non-citizens would just collapse.
It wouldn't exist.
But by using person, they codified a protection that is, I guess, philosophically based on a natural rights tradition. It exists separate from any administrative status defined by the government.
It's a territorial application of rights. And that interpretation, it emerged early and definitively. The courts, they quickly confirmed the broad, universal application of these rights to anyone physically present in the U.S.
And the historical context here is key. We go all the way back to the post-Civil War era for this.
You do.
What's the first big case that really clarifies this?
So you have to look at Yickwo v. Hopkins in 1886. Now, this case didn't involve immigration status directly. It involved a Chinese national, not a citizen, who was running a laundry in San Francisco.
Okay.
And San Francisco passed these ordinances that were, they were clearly designed to shut down laundries run by Chinese residents.
Right, they were discriminatory on their faith.
Completely. And the Supreme Court confirmed that the 14th Amendment applies universally to all persons within a state's jurisdiction, even if they aren't citizens. The city's ordinance, the court found, violated the equal protection rights of the Chinese laundry owners.
So even 138 years ago, the Supreme Court was confirming that the guarantees of the 14th Amendment apply to residents based on location, not just citizenship paperwork.
That's right. And then, 10 years later, in 1896, the Supreme Court took that concept and explicitly applied it to non-citizens who were unlawfully present or subject to exclusion proceedings.
You're talking about Wong Wing v. United States.
Exactly. This case involved the arrest and detention of Chinese laborers who were subject to deportation. The court ruled that the Fifth and Sixth Amendments apply to all persons within the territory of the United States.
So it explicitly includes aliens.
Explicitly. Even those unlawfully present when they are challenging actions by the federal government that subject them to what they call infamous punishment. The court drew a crucial line.
What was the line?
While deportation itself is an administrative process Congress can regulate, any punishment attached to that process, like hard labor or jail time, must adhere to the constitutional guarantees of the Bill of Rights.
Including a trial by jury.
Including trial by jury. That's fascinating, right? It established this early and robust legal precedent that constitutional rights follow the person, provided they are physically within the territory and subject to its laws.
So the foundation is clear.
Yeah.
If you are on U.S. soil, the Constitution guarantees you certain rights because you're a person, regardless of whether you have a specific government-issued document.
And that leads us directly to the most vital protection afforded to any person.
Due process.
Due process.
So if the constitutional cornerstone is the word person, the most important structure built on that cornerstone is the right to due process. What does due process practically mean in the highly specific and often murky world of immigration law, especially given that the consequences can be so severe?
Well, in the immigration context, due process generally refers to the right to fair treatment. It ensures the government can't just act arbitrarily or, capriciously.
So what does that look like?
According to constitutional scholars and legal sources, this includes appropriate notice of any pending government action. Specifically, the issuance of a charging document like a notice to appear.
An NTA?
The NTA, right. And the opportunity for a meaningful legal hearing or screening interview to determine if the individual can be legally deported.
It essentially means you cannot be arbitrarily detained or deported.
Mm-hmm.
You can't be punished without the government going through a formal legal hearing, even if your presence here is currently unauthorized.
Right. It's absolutely designed to prevent government abuse of power. For undocumented immigrants facing deportation proceedings, due process guarantees specific things.
Like what?
They have the right to be informed of the specific charges against them, which is listed on that NTA. They have the right to present evidence, call witnesses, and cross-examine government witnesses in their defense.
And they can appeal.
And they are afforded the opportunity for appeal before an immigration judge, and then often subsequently to the Board of Immigration Appeals, or BIA, and sometimes even federal circuit courts.
Now, this is where we have to talk about the huge technical difference that often confuses people. This process deportation proceedings, it sounds like a criminal trial, but we know it's not.
Yeah.
It's a civil administrative matter.
And this distinction is the source of, profound inequity in the system. When an undocumented person faces criminal charges, say for theft or assault, all the high standards of the Bill of Rights apply.
Right, the whole shebang.
The whole shebang. The state must prove guilt beyond a reasonable doubt. The defendant has the right to a jury trial, the right against self-incrimination, and crucially, the right to government-appointed counsel if they cannot afford one.
Right, that's Gideon v. Wainwright. So if you're poor and facing criminal prosecution for shoplifting, the government has to provide you with a public defender.
Exactly. But if that very same person is facing immigration deportation proceedings, which could result in their permanent separation from family, loss of employment, and removal to a country they haven't lived in for decades.
The stakes are just as high, if not higher.
Exactly. But those proceedings are categorized as civil administrative matters.
And because they are civil, those higher criminal standards just, poof, they don't apply.
Correct. The government only needs to meet a lower burden of proof, often just preponderance of the evidence. And the stringent rules of evidence are relaxed.
What does that mean?
For instance, immigration courts are generally permitted to consider hearsay evidence statements made outside of court, which would be completely inadmissible in a criminal proceeding.
Wow.
And this lack of criminal protection leads directly to one of the most critical dilemmas: the right to counsel.
Okay, so undocumented immigrants do have the right to an attorney in immigration court.
Yes, they do.
But, and this is a huge but, they do not have the right to a government-paid lawyer.
That is the caveat that dramatically shapes outcomes. Because deportation is deemed civil, the Sixth Amendment guarantee of appointed counsel does not apply. If you are poor and facing a life-altering deportation, the financial burden of counsel falls entirely on you.
You have to find your own lawyer, pay for your own lawyer, or find one of the very few pro bono services.
Which are incredibly scarce, yes.
Wait a minute. If the government knows, and we have statistics that we'll cover later, that representation often increases a person's chance of success by, what, 400 or 500%? Isn't the lack of funding for attorneys in civil deportation cases an intentional, systemic undermining of the constitutional guarantee of fairness and due process?
That is precisely the argument made by critics and civil rights advocates who call this a two-tiered system of justice. The right to counsel is theoretical if it's financially inaccessible.
So the right exists, but there's no way to use it for most people.
In the criminal context, the state provides counsel because it acknowledges that an unrepresented individual cannot adequately defend their liberty interest. In the immigration context, the government argues its priority is efficient enforcement, not funding defense services.
Despite the enormous liberty interest at stake, the right to remain in the country.
Exactly. This systemic tension is the central tragedy of modern immigration law.
Understanding that high-stakes tension rights exist, but access is throttled, sets the stage perfectly for how these protections function, or sometimes fail to function, in the real world. Let's shift now to the specific practical rights that non-citizens exercise on a daily basis within the U.S., starting with law enforcement encounters.
Let's do it.
Moving into the practical realm, let's start with the most common interaction people have with law enforcement, whether it's local police or federal agents. Criminal detention and questioning. If you are an undocumented immigrant, do you have the Fifth Amendment protection equivalent to Miranda rights?
Yes, absolutely. That protection is universal. The Fifth Amendment right to remain silent and the right against self-incrimination apply to any person, regardless of their immigration status.
So if you're in custody, ICE or CBP has to read you your rights.
They must read you your Miranda rights if you are in custody and they intend to interrogate you. And anything you say can and will be used against you.
What's the practical implication here? What's the advice?
The implication is that exercising that right to remain silent is perhaps the most important defense available. Law enforcement officers and district attorneys frequently use a person's undocumented status as a pressure tactic.
They'll say something like, cooperate with us and we'll help you out.
Exactly. They suggest cooperation is the only way to avoid deportation. But the right to silence remains non-negotiable. Legal experts stress that the only information an undocumented person must provide if detained is their name, date of birth, and country of origin.
And beyond that.
Beyond that, silence is protection.
And what about the physical act of enforcement, especially when it comes to private property? We often hear the phrase, they need a warrant. Is that true for ICE or CBP entering a home?
This is a critical point governed by the Fourth Amendment protection against unreasonable searches and seizures, which, again, extends to private homes occupied by any person. Generally, ICE or CBP needs a warrant signed by a judge to enter a private home.
A judge. That's a key detail.
A very key detail, because there are two types of warrants. A judicial search warrant signed by a court for a criminal search, and an administrative removal warrant, which is just signed by an ICE officer.
And I assume the judicial search warrant is what's needed for forced entry.
Correct. The sources emphasize that ICE agents almost never have a judicial warrant to enter a specific home. An administrative warrant of removal is not sufficient to force entry into a private residence without the occupant's consent.
So what should you do if they show up at your door?
If agents do claim to have a warrant, they must be told to slide it under the door or hold it up to a window so the occupant can examine it. You need to ensure it has the correct name, address, and is signed by a judge.
And you don't have to open the door.
You do not have to open the door to talk to them. And doing so makes it much harder to refuse questioning.
Okay, beyond initial questioning, there's the issue of detention itself. Are undocumented immigrants protected from being held indefinitely while their case proceeds?
They are. Due process ensures that. Undocumented immigrants retain the right to challenge unlawful government actions, and importantly, they are protected against indefinite detention.
And this was affirmed by the Supreme Court.
Yes, in major Supreme Court cases, notably Zadvitas v. Davis. That ruling established that the government generally cannot hold non-citizens indefinitely after a final removal order has been issued, unless there is a significant likelihood they will be removed in the reasonably foreseeable future.
So due process applies even to the execution of the removal.
That's right. And many detained immigrants can request bond release, correct?
That is the historic rule. Many detained immigrants have the right to request bond release while their deportation cases proceed before the immigration court, based on factors like flight risk and danger to the community.
But we're going to get into this later. That right is being severely restricted now.
Yes, as we will discuss in depth later, recent policy changes and legal rulings have dramatically restricted the ability of immigration judges to conduct these bond hearings in many cases, often leading to mandatory detention.
A huge, huge change.
Now let's tackle a right that impacts millions of families and is often hotly debated: the right to education. If a child is undocumented, Are they entitled to attend public K-12 school?
Yes, unequivocally. This stems from the landmark 1982 Supreme Court case, Plyler v. Doe. This is a must-know case for anyone interested in this topic.
So what was the situation in Plyler?
The state of Texas had passed a statute allowing local districts to charge tuition or entirely deny free public education to undocumented children. The Supreme Court, based on the Equal Protection Clause of the 14th Amendment, struck that law down.
What was the specific legal strategy Texas employed, and how did the court counter it? Because, as we noted earlier, education is not typically considered a fundamental constitutional right.
Right, it's not. So Texas argued two main points. First, that excluding these children would deter further unauthorized immigration, and second, that they were simply trying to preserve scarce financial resources for legal residents.
The money argument.
The money argument. They claim that the high cost of educating an ever-growing population of unauthorized students was burdensome.
And the court rejected these fiscal and deterrence arguments.
The court employed what's called intermediate scrutiny. They recognized that while Texas has a legitimate interest in saving money, the specific policy was disproportionately punitive.
Punitive to the kids.
To the kids. The court stated that denying K-12 education imposes a lifetime hardship on a discrete class of children not accountable for their disabling status. The children themselves are not responsible for their parents' actions or their legal status.
So the rationale hinged on the long-term societal cost.
Precisely. The court found that denying these children a basic education ensures they will lack the minimal skills necessary for functioning within civic institutions. It forecloses any realistic possibility that they will contribute meaningfully to the progress of the nation.
In essence, the court said Texas was creating a permanent, poorly educated underclass that would become a burden on society later.
Exactly. The short-term fiscal savings were outweighed by the long-term societal damage.
That is a powerful statement, recognizing the long-term societal cost of creating a shadow population. What does this ruling mean in practical terms for schools trying to enroll students today?
It means that compliance is non-negotiable. Schools are strictly prohibited by federal law and precedent from requiring students or parents to disclose or document their immigration status.
And they can't do things that might scare people away.
Right. They cannot engage in practices that create a chilling effect or hinder access, and this includes student support services as well.
Are there still common enrollment mistakes schools make?
Oh, absolutely. The sources note common administrative errors, often rooted in just a misunderstanding of the law, where schools mistakenly require state-issued driver's licenses or social security cards.
Documents that an undocumented family just wouldn't have.
Exactly. Documents that are only available to U.S. citizens or lawful residents. If an application requires a document related to lawful status, the school is violating Plyler v. Doe. They have to accept alternative forms of identification and proof of residence.
Like utility bills or consulate documents.
Exactly. So even if a state or local district tries to pass an exclusionary law today, the 1982 Supreme Court precedent stands as a massive, non-negotiable shield, forcing states to provide K-12 education regardless of status.
We've covered procedural rights in education. Now let's look at the First and Second Amendments, the rights to speech and to bear arms. These are often viewed as the quintessential privileges of citizenship. Do these rights extend to non-citizens?
They do, though often with serious caveats. Generally, the Supreme Court has ruled that the First Amendment freedom of speech, press, religion, and assembly applies to non-citizens who are lawfully residing in the U.S.
So legal permanent residents.
Right. And by extension, it also applies, albeit more precariously, to undocumented persons already present.
Okay, where does the constitutional protection start to thin out, especially for undocumented individuals?
The protection thins out severely when we talk about political speech and actions that might be deemed, detrimental by the federal government, particularly immigration authorities.
So it's about what you're saying.
And where you are. The government has traditionally claimed greater power to restrict the First Amendment rights of aliens seeking entry. This is tied directly to the plenary power doctrine we will discuss later.
Right.
Cases like Nafis Shaughnessy and Kleindienst v. Mandel establish that the government only needs a facially legitimate and bona fide reason to deny entry to a non-citizen, even if that non-citizen is a recognized international speaker invited by U.S. citizens.
That's at the border. But for someone already here, the expectation should be full First Amendment rights.
Yeah.
Like protesting government actions, right?
In a theoretical sense, yes. But the practical reality is a minefield. while the law guarantees the right to protest, engage in political association, or critique government policy.
Yeah.
The sources warn that engaging in speech disfavored by the government, like organizing political protests or joining certain activist groups, means non-citizens, particularly those without lawful status, must be exceedingly wary.
Because the government could use that against them.
The government has successfully used, and still attempts to use, certain speech or association records as a basis for deportation, often relying on expansive national security or public safety definitions.
So the threat of removal acts as a major chilling deterrent. The right exists on paper, but exercising it comes with extreme legal jeopardy.
Exactly. The risk calculation for a non-citizen engaging in public political speech is fundamentally different and far higher than for a citizen, which severely limits the effective exercise of that constitutional right.
That sets up a great contrast with the Second Amendment, the right to bear arms. This area is seeing active legal challenges following the Supreme Court's 2022 Bruin decision and the subsequent Rahimi case. Where do undocumented persons stand on firearms possession?
Well, federal law is quite explicit and has traditionally been upheld. 18 U.S.C. Section 922 G5 bans firearm possession by anyone unlawfully present in the U.S., as well as non-immigrant visa holders.
So it's like a flat ban.
A flat ban, and it's been on the books for years.
But the Bruin decision fundamentally changed how courts analyze Second Amendment restrictions. It now requires the government to prove that any firearm restriction is consistent with the nation's historical tradition of firearm regulation. How does the government try to historically justify disarming all undocumented immigrants?
It's a huge challenge for the government. They try to draw analogies between undocumented persons and historically disarmed groups, such as, convicted felons, the mentally ill, or those deemed politically hostile or disloyal to the country.
Like loyalists after the revolution.
Like loyalists after the revolution or specific enemies of the state. But the key difference is that an undocumented immigrant is not inherently a convicted felon or an enemy combatant.
Yeah.
They are defined by an administrative status, a civil violation.
Right. It's a status, not an action.
That is the core of the challenge against the law. Opponents of the ban argue that Congress cannot simply designate millions of people as universally dangerous and disarm them all without a historical analogy that specifically targets status alone, rather than individual criminal behavior or mental health.
And the Supreme Court in Rahimi kind of touched on this.
Yes, the Supreme Court in the United States v. Rahimi suggested the government can only temporarily disarm individuals found by a court to pose a credible threat to public safety. A blanket ban is much harder to justify.
And the sources point out data that undermines the government's broad dangerousness claim.
Absolutely. Statistical analyses consistently indicate that immigrants, including those present unlawfully, commit crime at lower rates than native-born U.S. citizens.
So the argument is that the government is imposing a burden on a constitutional right based on a generalized, non-historic fear, rather than established legal principles related to public safety.
Precisely. And this law is currently under rigorous challenge in the lower courts, forcing the government to find a definitive historical footing for the ban on an entire civil status group.
Finally, let's briefly touch on basic human welfare,
Oh.
healthcare and family rights. Are there constitutional guarantees here?
On healthcare, the constitutional floor is set low but firm. Federal law guarantees the right to emergency medical care regardless of status.
All right, through MTLA.
Primarily through the Emergency Medical Treatment and Labor Act. Hospitals and medical professionals cannot turn someone away in a life-threatening crisis.
But just for emergencies.
Just emergencies. Beyond that, the right is not constitutional, but community health centers often step in, providing low-cost or sliding-scale services, offering a crucial lifeline for non-emergency care.
And what about the right to family integrity? If a parent is undocumented, can the government simply split that family up?
No, not arbitrarily. Although family integrity is not explicitly written in the Constitution, courts have established a right to familial association through due process rulings that date back to the early 20th century.
So what does that mean in practice?
It means the government cannot arbitrarily split up families without going through a proper legal process that respects due process, even in situations involving deportation. This principle was notably cited when challenging certain family separation policies at the border.
The argument being that the government must have a legal, individualized justification beyond just administrative convenience to sever those fundamental familial relationships.
Exactly. It's clear that the application of person covers critical protections, due process, fair criminal treatment, K-12 education, emergency health care, and protection against arbitrary family separation.
Now that we've established the broad constitutional floor guaranteed to all persons on U.S. soil, especially due process, we will pivot and identify the ceiling.
Right.
What rights are explicitly not extended to undocumented persons?
Right.
This is where the difference between constitutional law and statutory law becomes not just stark, but politically crucial.
This section defines the boundary between fundamental rights and legislative privileges. The rights that are restricted are overwhelmingly statutory benefits and political privileges established by Congress, not the inherent constitutional protections we just discussed.
Let's start with public benefits, which are frequently the subject of political debate and often the source of major confusion among the public.
This is where Congress has exercised its power most aggressively. Undocumented immigrants are restricted from accessing most major federal public benefits.
And this is thanks to a specific law.
Yes, this restrictive framework is primarily the result of the Personal Responsibility and Work Opportunity Reconciliation Act, known as PR WARA, passed in 1996.
Why was PR WARA so pivotal in 1996?
It was part of sweeping welfare reform. PR WARA explicitly established that non-citizens are generally ineligible for federal public benefits. It divided immigrants into qualified, like legal permanent residents, refugees, asylum seekers, and non-qualified.
And undocumented persons are in the non-qualified group.
Yes, and that group was essentially barred from most programs, often for life.
Can you detail the specific programs they're excluded from?
This includes nearly all of the major assistance programs, SNAP, which is food stamps, general Medicaid eligibility.
With exception of emergency care.
Right, with that key exception. Also Medicare, Social Security, temporary assistance for needy families, or TNF, and supplemental security income, SSI.
So if you hear the political argument that undocumented immigrants are a massive drain on welfare programs, the legal reality is that, with the few exceptions of things like emergency rooms or very limited nutrition programs for children,
Right.
federal law strictly prohibits their access to the large cash or benefit assistance programs often referenced in those debates.
Precisely. They are legally barred from accessing those taxpayer-funded statutory programs. The system is designed to limit them to working, paying taxes, and relying on private or charitable resources.
Next, the most obvious exclusion: the right to participate in the democratic process.
This is a clear line. Only U.S. citizens can vote in federal and state elections or hold federal or state office.
And trying to vote is a huge risk.
A very serious crime that could lead to prison time or deportation. The right to political participation is explicitly reserved for citizens.
But you mentioned a fascinating nuance regarding local elections.
Yes. Because elections are largely administered by local jurisdictions, some local governments, like those in Chicago, San Francisco, and certain counties in Maryland, have exercised their home rule authority to permit non-citizens to vote in local elections.
But only local ones.
Only local, typically for school board positions or other local issues that directly affect them, but this is highly localized and does not extend to any state or federal office.
And finally, the immigration status itself. They can't just petition to become legal residents the way a spouse of a citizen might if they entered legally. This involves concepts like entry without inspection.
EWI, yes. This is crucial for understanding the difficulty of getting in line. If an immigrant committed entry without inspection, meaning they crossed the border without presenting themselves to an immigration officer at a port of entry,
They're in a different category.
a completely different category. They are generally not eligible to adjust to lawful permanent resident status to get a green card from inside the United States.
So if you enter without inspection, you're fundamentally blocked from the standard path.
Yes. They are often forced to leave the U.S. and apply for visa at a consulate abroad. And here's the complication. Accruing unlawful presence triggers harsh re-entry bars.
So just by being here, you're building up a penalty.
A penalty that activates when you leave. If they are unlawfully present for more than 180 days but less than a year, they trigger a 3-year ban from returning. If they are present for a year or longer, they trigger a 10-year ban.
So the act of attempting to legalize their status requires leaving the country, which then triggers a massive 3 or 10-year ban from returning. It makes the process practically impossible for most.
It creates a catch-22. Furthermore, they cannot receive lawful work authorization or petition for most visas while unlawfully present. This shows the clear line. You have the fundamental rights of a person on one side, but the restrictive, often punitive statutes of a non-citizen on the other.
This clear statutory exclusion leads us perfectly into our final and perhaps most complex section: how the federal government's enormous power in immigration matters often undercuts these constitutional rights in practice.
Right.
When we talk about the government's power over immigration, we have to confront the plenary power doctrine. This phrase sounds like a constitutional nuclear option. What exactly is it, and how does it affect the due process rights we just discussed?
The plenary power doctrine is a historical legal principle granting Congress nearly absolute exclusive authority to regulate all aspects of immigration,
All aspects.
from who enters the country to the terms under which they reside or are removed. It is considered an inherent attribute of the U.S. as a sovereign nation, necessary for national security and foreign policy.
How absolute was this power historically, especially in the 19th century?
It was incredibly absolute, and its origins are, well, they're problematic. It was codified during the era of the Chinese Exclusion Acts.
Okay.
In cases like Che Jianping v. United States in 1889, the Supreme Court declared that the government's determination on who to exclude was conclusive upon the judiciary. The court explicitly stated that these issues were political questions, removing them from typical judicial review.
So, the judiciary essentially gave Congress and the executive branch a blank check to act in the name of sovereignty and national security, even if the action seemed discriminatory or violated individual rights.
Exactly. While later in the 20th century the court began exercising limited review, the standard remains highly deferential to the government. This is especially true at the border.
This is where cases involving exclusion at the border, like the travel ban case, Trump v. Hawaii, come into play.
Yes. In Trump v. Hawaii in 2018, the Supreme Court reaffirmed that judicial review of executive decisions to exclude aliens seeking admission is highly constrained.
What does that mean, highly constrained?
It means courts only require the government to articulate a facially legitimate and bona fide reason for the denial of entry. The court will not look behind that justification, even if the policy allegedly burdens the constitutional rights of U.S. citizens seeking communication with the excluded alien.
So if you're standing outside the door seeking admission, the constitutional rights you have are far weaker, almost non-existent, compared to the robust due process rights afforded once you've physically stepped inside the territory.
That is the line drawn by the courts. However, scholars argue that this deference has led to what they call rights retrenchment, even for those inside the U.S.
So it's creeping inward from the border.
Many observers believe the modern Supreme Court has reinforced the plenary power doctrine, effectively removing much of immigration regulation from traditional constitutional scrutiny, leading to a scaling back of protections in areas like habeas corpus and procedural due process.
So the government uses its plenary power to create efficient mechanisms of removal that skirt the slower, more robust due process afforded by full court proceedings. This brings us to expedited removal.
Expedited removal is a primary tool for rapid enforcement. It allows for fast-track deportation without a hearing before an immigration judge.
And who does this apply to?
This process applies primarily to immigrants in the country for less than 2 years and who are apprehended within 100 miles of the U.S. border. It's designed to be swift and administrative.
That sounds like a complete denial of due process. Where's the constitutional check on that?
The constitutional check comes in the form of the asylum exception. Due process demands that if a person subject to expedited removal expresses a fear of persecution or an intention to apply for asylum,
They get a chance to make their case.
they must immediately be granted a chance to present their case to an asylum officer for a credible fear screening interview. If they pass that screening, they are then referred to a full immigration court proceeding, thus restoring a degree of due process.
And if they fail?
If they fail the screening, the removal is executed immediately.
Beyond expedited removal, there are massive policy shifts altering detention requirements. We mentioned restrictions on bond earlier, and this is where the matter of Yajuha Hurtado ruling comes into play.
This September 2025 ruling by the Board of Immigration Appeals is an enormous game changer, with massive practical implications for due process.
How so?
Historically, many detained immigrants could request a bond hearing to argue for release while their cases proceeded. The Yajuha Hurtado ruling effectively states that immigration judges lack the authority to conduct bond hearings for individuals who entered the country without inspection, EWI.
So if you cross the border illegally, you are now subject to mandatory detention, regardless of whether you have family, a job, or deep community ties, until your case is decided.
That is the consequence. Because EWI triggers this mandatory detention, it removes the judge's discretion to release the person on bond. This ruling potentially impacts well over 1 million pending cases.
And means that most undocumented immigrants now face mandatory prolonged detention throughout their proceedings.
Yes, and given the immense court backlogs, this mandatory detention can last for years.
Mandatory detention for 3 years or more. This brings us directly to the systemic barriers that practically nullify those beautiful constitutional guarantees we started with. This is the reality of the two-tiered system.
The contrast between the legal right to due process and the practical ability to access it is devastatingly stark.
Let's start with the representation crisis and the overwhelming court backlog.
The statistics are horrifying. Currently, 67% of people in immigration court lack legal representation.
2 out of 3 people.
2 out of 3. And this rate plunges even lower to only 14% for detained immigrants.
Why so low for detained immigrants?
Because detention centers are strategically located in remote areas, far from major cities where legal services and attorneys are concentrated. It isolates the vulnerable population.
And what is the outcome disparity? How much does legal counsel matter in this system?
It is the single most important factor. The data shows that represented immigrants who are never detained succeed in 63% of their cases, often by proving they are eligible for some form of relief.
And without attorneys.
Compare that to just 13% for those without attorneys. For detained individuals, the benefit is still massive. Representation nearly doubles the success rate, from 23% to 49%.
This proves the point we made earlier. The system functionally undermines the right to due process by failing to ensure accessible representation. It makes the outcome dependent on wealth, not merit.
Absolutely. The ultimate consequence of this representation gap is mass procedural failure, specifically in absentia removals.
Meaning they get deported without ever showing up to court.
Right. 90% of unrepresented immigrants who receive removal orders are removed in absentia, meaning they are deported without ever physically appearing before a judge, often because they never received proper notice or couldn't navigate the complex court requirements.
And how does that compare to represented immigrants?
The contrast is shocking. Only 29% of represented immigrants are removed in absentia, and 96% of represented immigrants attend all their scheduled hearings.
So lack of representation doesn't just reduce success, it virtually guarantees procedural failure and removal without a full hearing on the merits of their case.
It's a procedural death sentence for their case.
The structural barriers go beyond just legal access, right? The system itself is grinding to a halt.
It is in crisis. The immigration court backlog has reached a staggering 3.7 million pending cases.
3.7 million.
With people waiting an average of more than 3 years for initial decisions. Other severe barriers include pervasive language issues. The court struggles to find interpreters for hundreds of indigenous languages spoken by people seeking asylum.
I can't even imagine.
And the aforementioned geographic isolation of detention centers. We also must note the vulnerability of children. The sources highlight the termination of federal funding for legal services for unaccompanied children in 2025, which leaves minors, who often have high rates of PTSD, to navigate this complex system alone.
Finally, let's look at the tension between state and federal authorities. Can states try to enforce immigration policy or create their own restrictions?
States can try, but the power of the federal government, based on the Supremacy Clause, is typically preemptive. The Supreme Court has repeatedly affirmed that immigration enforcement is fundamentally a federal matter.
Give us an example.
For example, a recent Florida law attempting to make it a misdemeanor offense to enter the state as an illegal immigrant was blocked by a federal judge, a decision upheld by higher courts, because states cannot trespass on federal enforcement authority.
But sometimes state laws are upheld, particularly if they mirror federal objectives.
Yes. State laws like Arizona's requirement for employers to use E-Verify have been upheld because they don't create new immigration violations, but instead mirror federal objectives regarding employment eligibility. This demonstrates that preemption cases are narrowly about the allocation of power, not the individual rights of non-citizens.
And what about sanctuary policies, which seem to actively limit cooperation with federal enforcement?
Sanctuary cities and states operate within their authority by limiting the cooperation of local law enforcement with federal agencies like ICE or CBP. These policies vary widely, but they generally prohibit local police from inquiring about immigration status or honoring ICE detainers without a judicial warrant.
So they don't stop federal enforcement.
Crucially, these policies do not prevent federal enforcement from operating, but they reduce the likelihood of local police initiating immigration-related detentions, creating a layer of protection for residents.
This entire section paints a dramatic picture where constitutional rights may exist on paper, but systemic limitations, legal complexity, and overwhelming administrative backlogs render them functionally inaccessible for millions, creating a legal system defined by its procedural barriers.
That's right.
Okay, let's bring this deep dive to a close. The core takeaway, driven by the sources we reviewed today, is simple but profound. The U.S. Constitution guarantees fundamental rights, particularly due process and equal protection, to every person on U.S. soil.
The Constitution is territorial, not strictly custodial. And that guarantee is primarily rooted in the due process and equal protection clauses of the 5th and 14th Amendments, leveraging the term person instead of citizen. This ensures that no individual can be arbitrarily deprived of life, liberty, or property.
And it mandates basic fairness, the right to challenge detention.
And access to K-12 education, as established by the landmark Plyler v. Doe ruling, which emphasized long-term societal stability.
But the paradox is that these constitutional protections are functionally undermined by statutory restrictions and aggressive federal enforcement mechanisms.
Yeah.
You're barred from most federal public benefits due to the 1996 PR WARA.
And increasingly, you face mandatory detention throughout your proceedings, as seen in the recent matter of Yajir Hurtado ruling for those who entered without inspection.
The critical thinking required here is distinguishing between these two concepts. The debate over immigrant rights in the political sphere is often focused purely on statutory benefits, which Congress has the plenary power to restrict.
And this political rhetoric often masks the enduring legal requirement for due process, which is mandated by the Constitution and cannot be revoked without amending the fundamental law of the land.
So, understanding that distinction due process is constitutional, welfare is statutory, is key to being well-informed on this topic. The legal system guarantees fairness, but statutory law restricts privileges.
Exactly. And when constitutional rights are not honored in practice, it's not because they don't exist, but because the systemic machinery, the massive court backlog, the location of detention centers, the lack of interpreters, and overwhelmingly the crushing lack of legal representation prevents individuals from accessing those rights.
The right to counsel is moot if you cannot afford it, and the government is not required to provide it.
Precisely.
Which leads us to a final provocative thought for you, the learner. We know from the data that the average immigration case takes over 3 years, and 2/3 of people in immigration court lack any legal representation, leading to mass in absentia removals. Given these documented system-wide barriers, what practical, perhaps non-traditional steps should the government take to ensure that the constitutional right to due process is not merely theoretical, but actively accessible for the millions of people whose lives hang in the balance of the immigration courts?